like in taxes, you have something that's exempt from tax. You owe it. They just don't make you pay it. Does that make sense? So this is a countable asset. It's a countable asset. We're just not going to count it. We're not going to consider it in our calculations. But it's still a countable asset. It never changes. So and you still own it. We never changed the ownership. It was still owned by the person. So at death, it's in their estate. They own it. It's property that's ripe to go after. So that's why estate recovery is always on the forefront, because we always want to make sure we don't leave anything on the table at death that they can come after. IRAs fall in that category. Okay, there's a lot of money in an IRA. It's designed to pay you through your retirement years. Some people have very large ones, and at death, there's a lot there.
Yeah.
And even though they're beneficiary-driven instruments, they are subject to estate recovery. Okay, prior to the beneficiary distribution. So we want to deal with those. So I always, when people say to me, or facilities tell people, "Oh, your house is a protected asset," my response is, protected from what? It's really just a deferral. We're just kicking the can down the road. They're not coming and taking the house while you're alive. Okay, now God bless them, they'll even wait until, if you have a spouse living in the home at your death, God bless them, they will wait until your spouse passes away before they'll come and take the home. But they will come and take it or exercise estate recovery. So I'm not a big fan on exempting anything. I know sometimes we get put in that boat, but if I exempt something, I do it on a very temporary basis. Here's my solution to the problem.
Okay.
And I wasn't going to get into this depth, but here I'm already fired up. And I'm on a roll.
I'm sticking with you.
Yeah.
This
good.
is interesting to me.
I'm on a roll. So here was my solution to the problem, because we actually are doing one just like this. So the person, we get down and they have this home. And let's use some round numbers like $300,000. They have this home. So what we can do is we're going to exempt it at first, because if we exempt it, we can file the application and get qualified rapidly.
Okay.
If we're going to do something with the house, that takes a little bit of time, and we delay our entry into filing the application. Because if you remember, when you file the application, that puts you in a special status now. We want to attain that status as soon as possible. So what we're going to do, if we're just let's just say we have somebody that's going in the home, but they have a $300,000 home, nothing much in the way of assets.
Right.
And so what we do is we go ahead and file the application, get them qualified. In other words, we're not going to hardly do anything up front.
Right.
Get them qualified, because TennCare will exempt that primary residence. So we tell them it's a primary residence, it'll be exempt. Now, they get approved. All right, now they're paying the bill, right? Now what we want to do is sell that house. Now, we either if it wants to stay in the family, we'll sell it to a family member. If it's something that, people say, well, if I inherit the house, we're just going to sell it anyway. So then we're going to go ahead and sell it, okay? Now, when you sell the house, you're in a situation now, the house is exempt, but the money you get for it is not, okay? So let's say we sell the house, we get $300,000 cash, right? Now what we're going to do is exercise one of our other strategies, that one I talked about not too long ago. Sometimes it's referred to as half a loaf, but I call it the gift / Medicaid compliant annuity, where we're going to take the $300,000. We're going to give $200,000 of that to one of the children as a gift, okay? That gift triggers a penalty, right? This is a situation where we know we're triggering a penalty. It's intentional. People say, why do you trigger a penalty intentionally? Well, we're doing it because it's working in our favor this time. So we know we're doing it. So we give away $200,000. That's going to trigger a penalty period. We're going to take the $100,000 we didn't give away, buy a single premium immediate annuity. It's called a Medicaid compliant annuity. And that annuity is going to start paying immediately, and it is designed to pay the exact cost of care for the exact length of that penalty period.
Okay.
So we maintain this status called otherwise eligible, but for the penalty. So when we do that, we have to notify TennCare that we sold the house, we got the money, and by the way, here's what we did with the money. We gave 2/3 of it away, we kept 1/3 and bought an annuity. And they're going to say, okay, you're in a penalty period for giving it away. It's like, yeah, we know that. Thank you, Sherlock.
Yeah.
we understand how it works.
Yeah.
But yeah, we know. And they said, okay, but as soon as the penalty period is expired, we'll start paying again, because we are eligible but for the penalty, which is the statutory language. So so we know that's going to happen. Now, the penalty period is based on the amount of money we give away. So it could be 10 months, it could be 24 months. If it's a very valuable house, it's going to be a long penalty period. But we're covered because we are structured to pay the cost of care, right? We're not, that's a loss. We're going to lose that money because we're using it for the cost of care. But the end result is we saved the $200,000.
Yes.
As opposed to doing nothing and leaving it exempt, dying with it exempt in your estate, and the entire thing is subject to estate recovery. Because if you have a $300,000 house at the tune of $120,000 a year in a staying there the average 3.6 years will consume that house.
It'll eat
Now,
it up, yeah.
what's a better option? Lose the entire house in estate recovery when you got heirs who thinking they're going to inherit mom's house
Right.
and end up with a big surprise that they're getting nothing, or they have to sell it to satisfy a huge debt, or getting the house because maybe we sold it to that family member for that fair market value, and saving the $200,000.
Yeah.
Now let's take it one step further.
Okay.
Let's say that's if it were in the fair market, they would have saved the $200,000, right? Suppose you were a family member and you said, I want to buy the house. Okay. And let's say it's a $300,000 house. And let's say the tax card value is what we have to buy it for to not suffer a penalty during the transfer. Let's say that's it's $300,000 house. Let's say that's $200,000 or $250,000.
Yeah.
So we buy it for $250,000. Now mom has this cash. Mom turns around and has to gift away 2/3 of it, right? Which is going to be somewhere around $180,000. Well, she's going to gift it to that person. And so now that person has the house for $200,000 minus $180,000. They just got $180,000 back
Yes.
of the $200,000 they paid for it.
Yep.
So they get the house for like $20,000 or $30,000.
That's correct.
I mean, so that's a pretty good deal.
Pretty
I mean,
good deal.
it takes a lawyer to screw something like that up, right? I mean, that's a pretty sweet deal. So there's a lot of ways we can actually make this penalty period that is so scary and so devastating work in our favor, or at least mitigate the impact of it. And that's what these things do. Now, that's a couple strategies tacked together doing that. So, like I said, I wasn't going to go into that, but the goal is to avoid estate recovery and to avoid this 5-year penalty rule as much as we can.
Right.
Often we get stuck with them to some extent, but it doesn't mean we can't mitigate the impact. We can.
That's a great story. I mean, a great strategy to see that actually unfold like that. Because I've seen circumstances in my business where, the TennCare has to be paid, and it takes a big lick out of the what would have been the estate, the entire estate. Had one fairly recently that didn't consume all of the money that was sold. We sold the real property, but it ended up taking a good chunk, probably close to half of the real estate worth.
And that is a shocking piece of news.
But that was, and in this particular case, they expected it, they knew it, they had already been made aware of the circumstance, and it just had to be done.
That's right. And I hate when I have folks like that. I hate to let them know it didn't have to be that way, because hindsight is hindsight,
Yeah.
But anybody that's not in that position, it doesn't have to be that way.
Right.
If we do something ahead of time, which I guess is the word planning,
Yes.
if we can do something ahead of time, we can avoid all that. We can
Yeah.
avoid all that. So if you're one of these folks that procrastinate and say, I'm just not going to mess with that, I mean, there's some consequences that can go with that. I mean,
That
so
is true.
That may be a good reason to get past the procrastination stage.
Very true.
And I often tell people this time of year, we're coming up on the holidays, right? Going to be family get-togethers and stuff.
Oh, yeah.
This is a really good time to maybe broach the family about stuff like this. Not like, what do you want when I'm gone, stuff like that. It's like, okay, your mom and I are thinking about doing some estate planning. We're going to talk about where stuff goes. When people report back to me when they have these kind of conversations, the overwhelming response is that the kids are all on board and say, good, I think that's a great idea that you do that. Get that taken care of, because otherwise we have to deal with it. And if you can take care of it, that's great.
Yes.
It's easier on us, and it's going to go where you want it to go. So it's kind of a good time to, talk about a topic that's usually not always overly popular, but I mean, it's a family topic.
It's not an easy thing necessarily to just jump into, but it's better than waiting. And I'll give you a little quick story. A good friend of mine from many years ago, a great older couple, and they were great friends of ours. And him and his wife, he told his wife that they needed to go and do their funeral planning. Now, they had everything else planned out. They had all their ducks in a row, but they hadn't planned their actual funeral. Well, she didn't want to do it. And he told her, he said, well, look, if we don't go do it together, one of us is going to have to do it by ourselves. And
Yep, there's some logic for you.
so that kind of satisfied her, and they went and did. So I guess that's what I'm saying about this. When you can bring this up, is that, look, we can do it now while I'm here, and we can talk about it and get it done, or somebody here is going to have to do it without me.
That's right.
And
that's a burden.
That's a burden.
It's a burden.
That's right.
And when you look at it from what the consequences are really going to look like,
Yeah.
that can be a mind changer and get you back on track to do it. I mean, we do things all the time that are unpleasant, but I don't even know if that even rises to the level of unpleasant. It's just not fun to talk about, but really everybody knows that mortality is a thing.
Yes.
Property is what you have, and when you start looking at it this way, if you're procrastinating doing something like this, think about it. I mean, you spent your entire life accumulating wealth, stuff I call it.
Yeah.
And whatever that is. Now
You build your American dream.
that's right. I mean,
that's right.
And it's whatever it is, it's yours. I mean, whether it's a whole lot or what you consider a lot or you consider a little or somewhere in between, whatever it is, it's yours. And you're proud of it. And you're jealous of it. And you want it. And you want to keep it for what you want to keep it for, use it for what you want to use it for, or give it away to the people you want to give it away to. Whatever that you want to do with your stuff is what is important to you. And you spend a whole lifetime getting this. Some folks will say, I don't care, I'll be dead, they can fight over it. I mean, I don't understand that concept, but most people, 99% of the people do care about it.
Yeah.
And they want to, everybody knows you can't take it with you, but you want to do something with it that's good if you're going to be giving it away.
Yeah, and that attitude could fix it where they don't get to fight over it. It's just gone.
That's right. That's right. So, if you think about it that way, and I actually somebody had a piece of land, and they were very, very specific on what they wanted done with it. But he said, I'm just not interested in doing any kind of planning, will or trust or anything like that. And what finally got his attention was I said, well, let me tell you what's going to happen if something happens to you and you don't have anything. Okay. You don't have a will, you don't have a trust. Everything you own, and this is a piece of property, he was married for many years, but this piece of property was just in his name. He had inherited it, and it was still in his name, and he wanted it to keep going down the pike, down the family chain.
Yeah.
I said, let me tell you exactly what's going to happen if you pass away without anything. Well, it's got to go somewhere. And since you didn't say where it was going to go, the laws of intestate succession now kick in. In probate, they're going to say, all right, if you didn't say where it's going to go, the state of Tennessee decides where it goes. And so, they're going to do is they're going to say, okay, you got the piece of land. We're going to look to see if you have a surviving spouse and who your descendants are. And we're going to divide it between them. And there's certain rules on how to do that. If any of those are gone, we're going to look to their kids. If they're gone, if there's nobody there, we're going to look up to see if your parents are still alive. If they're not there, we're going to look sideways to your siblings. And it goes on and on. There's a scheme of searching for somebody for it to go to.
Yes.
And what would have happened was about 180 degrees different than what he wanted to have happen. And I said, so if this is really important to you, and he said it is. This is extremely important to me that this go this way. I said, here's what's going to happen if you don't do anything. The exact opposite is going to happen. And so if that, the choice is yours. I'm not here to talk anybody into anything or talk anybody out of anything.
Yeah.
But I'm just saying that the cold, hard truth of the matter is if you don't put something in place for this unique distribution that you want, that's the only way it can happen.
Yeah.
Now, if you put it in a trust, we can make it enforceable, and I can guarantee you that's the way it'll happen because of the instruments, the laws, and what we have to work with.
Yeah.
That's what'll happen. But we've got to say it, and we've got to memorialize it into an enforceable agreement so that when you're gone, your intent and your wishes is there and memorialized in this legal document that governs the control of it, the descent and distribution. So, again, I get the procrastination thing. I used to tell this story. If you're procrastinating, don't feel bad. I did myself, and I'm going to tell a very embarrassing story. So I'm going to wear my heart on my sleeve on this. We talked before about practicing the law being a second career for me, right? Well, I actually started practicing in 2003. I think I passed the bar in 2002, but I officially opened my practice like January 1st of 2003.
Yeah.
Well, I'd been practicing law for 7 years, so somewhere around 2010. And I didn't even have a will. I didn't have a will, didn't have a trust, didn't have anything. I wasn't doing estate planning back then, but I didn't have anything. Okay?
Oh, wow, okay.
And I've been practicing law for 7 years, and I even took a course in my third year of law school called wills.
How about that?
And I didn't do it. So if that's not bad enough, okay, first of all, that's embarrassing enough, but it gets worse. My wife and I did a will, and we hurry up and did one about 8 o'clock at night on the night before we got on an airplane and went on a vacation where we were leaving our 3 minor children with grandma.
Okay.
So it was just my wife and I were going on vacation. We were meeting some family members of hers in the Caribbean, and the kids were young, and so we left them with grandma. And we did this like after hours, and got people to witness it for us, and just right under the wire. And it was just your basic will. I just said, okay, we leave everything to kids.
Yeah.
I mean, just to get something done.
Yeah.
Now, that's embarrassing. So if you are procrastinating, it's gonna be hard for you to top that. But here I am, a professional. I should know better. I should have known better, right? And I still didn't get it done. So I use that as an example. Don't feel bad if you procrastinate. Everybody does.
That gives you a certain sense of, I guess, empathy for people who are going through all this stuff.
I'd say 99% of people who talk to me say, we've been talking about this for months or a year, and we just decided to pull the trigger and do it. So they procrastinated. And I'll tell you what, a lot of the procrastination comes from not knowing what your options are.
Yeah.
And that's the problem. That's why the seminars of mine became born. That's why we started doing this years ago. People come in and say, well, I want to do a will. And I say, well, great. You want to hear about some other options? I didn't know there were any other options. I thought a will was all you could do. Mm-hmm. And it's not. You listen to me talk, there's other things to do. So I started these seminars to let folks know that, maybe you're procrastinating because you don't know what all's available to you to do, especially in this long-term care thing. If you ask anybody on the street, I guarantee the answer is going to be something like, oh, they're just going to get all your money. There's nothing you can do. You're just SOL. They're going to get it all, and that's all there is to it. I guarantee you that's the misinformation that's out there.
Yeah.
And it's not. It's not. Some of the examples I just off the top of my head today show you we can salvage tons of money.
Yeah.
And it's not all lost. So, but if we're not to be lost, we have to do something. Nothing happens automatically. But certainly nothing favorable happens automatically.
Yeah.
So, that's a state recovery I wanted to talk about, because that is out there. It's misunderstood, and it can be a real whammy after death, because now it's too late to really do anything. Mm-hmm. And there they are with their hand out and a bill. And I'm going to tell you what, when you get the TennCare bill, and here's where you get it. People say, well, I don't know if I have a daddy or mom have a TennCare bill or something. Here's where you get it. By law, every probate estate must file a TennCare request for a release.
That's correct.
And when I used to do probate, like I've said many times, I don't do probate anymore, but when I used to do probate, I would say, okay, we need to file this release to TennCare. And they said, well, Mom and Dad never were on TennCare. I said, no, but we got to file a release. Why do we have to file a release for something they never had? I said, it's a law.
It's a law.
And they said, well, it's stupid. I said, yeah, it is stupid, but I mean, it's a law. Here's why you have to do it. It brings to their attention that somebody has passed away, and then they go look to see, have we paid benefits for this person? Exactly. And a lot of times when they tell me that, 2 weeks later I get something in the mail that says TennCare we have no claim. So here's a release of claim that we don't have one. And it's like, okay, you're right, but we have to have this by statute of the probate court.
I see it all the time.
Before the court will close the probate estate, you have to have that release in there. On the other hand, sometimes we get it back, and they'll say you have like this one, a $216,000 claim on the estate. And this claim we got was 22 pages long. They itemize everything they paid for.
Oh, wow.
It's just not a blanket claim. It comes itemized. And it's incredible how detailed it is. It blows my mind. 22 pages this thing was, but some total $216,000. And they're saying, we have a claim. Now, they're one of the creditors in the probate process. Mm-hmm. And we can't close the estate until we satisfy the creditor. Now, like I said, sometimes they'll let you buy it back. And, sometimes we can make that work for us, too. Yeah. Here's a way we can make that work for us. When they have a claim, mm-hmm. and you want to buy them off, there's two things you can do. One, it's kind of like monopoly money. Even though the person was paying, it was $9,000 a month, that's not how much TennCare pays. We call it the TennCare reimbursement rate. It's something less. Yes, something it's kind of like insurance. You know what I mean? Yes. Here's a good example. I go to my doctor and I get a physical, and physicals are never covered under your insurance unless you're, mm-hmm. Hardly ever. Yeah. And so they say, okay, this is a $200 medical exam, and your insurance doesn't cover it. You owe us $200. And so I call them and say, look, my insurance doesn't cover that, so what's the non-insurance rate? They say, okay, that's right, that's not insurance. Just send us $85, we'll call it quits. Yes. So there's this funny money. There's this yes. I don't know what to call it, but it's the reimbursement rate is different. Yes. And so when you buy it back, we can buy it back at this reimbursement rate, which is less. We can make that work for us. We can also negotiate it. TennCare is not in the business of having houses. It's not like they collect all these houses and they're all piled up over here somewhere. Yes. They're collecting them all and renting them out to people and doing something with them. They want the money. They don't want the house. Right. And if they get a house, if they force the sale of a house, or if they seize a house, they've got to hire somebody to sell it. Somebody like you do auction stuff, don't you?
I do.
We got to get somebody like you that's going to take it over, sell it, and they got all this cost of doing that. And the bottom line is they'll end up with some of the money. That's estate recovery.
Yeah.
So I've done this before. We had a house and it was like, I don't know, it was worth like $100,000. Fair market value. I said, look, if you auction this off, the best you're going to do is like 75, and you're going to spend probably $20,000 hiring people to do this, do that, and all that stuff like that. So the best you're going to really get out of this thing is like $55,000.
Mm-hmm.
How about we give you 40 or 45,000 buyback? They will entertain that offer, and they'll say, I'll get back to you. And they'll go back and they'll scratch it, sniff it, they'll run the numbers, they'll get the bean counters, and they'll come back with another number. I think in this case, I said, how about they came back with something like $49,252, and we'll settle the claim.
Yeah.
And so you can now. What's the result of that? Okay, we bought the house back. It was a $100,000 house. We didn't inherit it free. It wasn't. We didn't just get this $100,000 for free.
Yeah.
But we did inherit a $100,000 house for $42,000,
Which
or whatever
makes
it was.
sense. Which makes sense to do.
It's better. It's not great, but it's better, right? It's not as good as it could have been, but so we can mitigate the impact of that sometimes. So state recovery is a real issue. It's out there, and I call it a sleeper because you don't see it out there. You don't know it's out there, and you may make decisions to just keep exempt property in the resident's estate, and then it will rear its ugly head at death, and now you're blindsided by it. So when we talk about it, we always keep that in mind and say, listen, here's this IRA. We can do this, but we can exempt it, but it's going to be, and you got $600,000 in there. You're never going to consume all that in your retirement years, so there's going to be quite a bit left at death. So we don't want that subject to estate recovery. So let's cash it out and roll it into a Medicaid compliant type IRA instrument that will be exempt from estate recovery. So there's all stuff we can do.
It's amazing.
Yeah, it is, and it's actually fun. I mean, I get a kick out of it. I still love what I do every day. I love going to the office every day. Every case is different. Now, I won't say when I love it and I get a kick out of it. I'm not unsympathetic to the people's plight that come to me especially when people are in the nursing home, and you're bleeding to death financially. I say that in such a way that I enjoy doing what I do. I can always come up with some kind of solution. As the engineer in me just loves to do that. And
it's satisfying. It's satisfying, I'm sure, to actually help somebody solve a problem, even if the problem doesn't completely go away. You've lessened the impact.
Actually, most of the times we can make it go away, but like you said, sometimes we are limited to what we can do, but we can always do something.
That's neat.
And that is satisfying. I guess is probably the better word for it. It's very satisfying to do that. I've always been a problem solver, and I love a challenge. But I am sympathetic to people's plight. I mean, they're worried, they're scared, they're financially bleeding to death. They don't know what's going to happen to them when it's all gone. And I get it. You should be worried about that.
Yeah, absolutely. Absolutely.
But but the takeaway is, and if you want to come to one of my seminars, we talk about that, especially the one we're going to be doing here in these next two. We discuss this long-term care thing in the second half of the seminar. So if you are worried about that and you got a loved one in that situation, don't take it alone. Don't try to do it alone. I often get asked to take what I call a do-it-yourself TennCare application.
Yeah.
It's already been submitted, possibly already denied, and now what? Okay, and so we have to fix it. And that's always a little more difficult than doing it in the first place.
Yeah.
Because you're kind of behind the eight ball with the first denial.
Yes.
Because there's certain things you can do while that application's pending, but once you get in denial and you apply again, you don't get that status necessarily again because you can't just keep doing that and filing one is going to fail, and when it fails, file another one to continue the status.
Right.
So you get the status on the initial filing. So there are certain things to keep in mind. But we did one case where the person came to me with tears in their eyes. They were so overwhelmed. They said this is the most horrible experience they've ever had in their entire life. They spent 6 or 7 or 8 months dealing with this. And I mean, they could probably come on here and talk for 2 hours about the horrible things they had to go through dealing with this. Finally, they just said, I don't know what to do. Can you just take this over? And it was a bit of a mess, but we managed to clean it up. And so, anyway, it's not a kind of thing I recommend you do on your own. You certainly can. There's nothing to keep you from doing it.
Right.
But you don't want to get in that scenario.
Right.
So.
Let's see if we're getting a phone call of interest here. Hey, good morning. You're on WDXE with us.
Good morning, Jeff. How you doing, brother?
Very good. How are you, buddy?
Good, good. Hey, I got a question for him. Just what I usually listen to y'all every Friday morning.
Yes, sir.
Thank you.
That's something we've never done. It's made because I just always figured something happened to me, it'd go to my wife or kids, and that's just something we've never done. And I'll listen to the radio. Just kind of answer that. Do we need to have go down like you said? Somebody's got to do it, but just answer that question for me. That, like I said, we've just never made a will or nothing. I just always figured it went to my wife or whoever's living. So appreciate it. Listen, I enjoy listening to you, buddy.
All right, I'm going to hang up and you listen on the air, okay?
I will.
I think his question goes back to what you were talking about. If you do nothing, then the state determines what happens. So maybe you want to review that just a second.
Sure. And, I guess doing nothing is a choice.
Yes.
It's not always the best choice, but doing nothing is, and a lot of people are in that boat because statistically, 12% of the people die testate, meaning they have a will.
Yes.
88% do not. Okay.
That's amazing.
So if you pass away with nothing in place, now what you can have in place is a will or a trust, right? There's only two options. But if you pass away with nothing at all, I often say the state of Tennessee, God bless them, writes a will for you.
Yes.
It's called the Laws of Intestate Succession.
Okay.
And because your property has to go somewhere, and you didn't say where, so they've already written those laws, and they've already decided who your heirs are and what percentages they're going to get. Okay, so the gentleman called. He didn't say how many children he got, but let's just go through that. If something happened to him, okay, the laws of intestate succession say, does he have a surviving spouse? And let's assume he does.
Yes.
And does he have any children? And let's assume he does. Let's assume he has a couple of children. The laws say we're going to divide it between the children and the surviving spouse. Surviving spouse gets a third or up to a child's share. Now, what that means is if there's only one child, the wife would get a half, and the child would get a half. If you have more than one child, so you have two children, each is going to get a third. And if you have 10 children, the spouse gets a third, and the 10 children divide 2/3, 10 ways.
Okay. So it doesn't everything doesn't automatically go to the wife.
That's right.
It's divided between the wife and children.
The children. Now, that is,
or the surviving spouse, I should say.
and that's a little bit tainted in the fact that that's talking about going through probate.
Okay.
Now, certain things don't go through probate. And when you're married for many years.
Yes.
So, you have jointly held property.
Yes.
Now, jointly held property goes to the other joint owner. It doesn't even go through probate.
Okay.
So, if you got a bank account, like this gentleman and his wife have a bank account, it's in both their names, they're both owners.
Yeah.
At his death, you just have one owner. So it never even really passes to the wife, but it kind of it's just now all hers, right?
Yes.
There's no actual passing, but she gets it all.
Okay.
How about the house? If this gentleman that called owns a house and the deed says him and his wife,
Yeah.
if you own property in Tennessee as husband and wife, it enjoys what we call right of survivorship.
Okay.
That's another way to pass.
Okay.
Probate avoidance.
So their home, if they're both on the deed, would go to the surviving spouse.
That's right.
Okay.
And joint ownership.
And joint ownership in any bank accounts would go to the surviving spouse.
And the other thing is beneficiary-driven instruments like life insurance. That goes to whoever you designate as the beneficiary.
Okay.
So here we have a situation where at the first death, probably, more than likely, if you've been married for any length of years, you're going to get that result. Just about everything's going to go to the spouse because you have most everything you own is jointly owned or right of survivorship. And if you have a life insurance policy, you probably named your spouse as the primary. So pretty much the end result. I mean, that's what the laws of intestate succession say, but that's dealing only with the probate estate. All these other things are passing outside of probate.
However, if the deed of the property is only in your name,
that must be probated, and that's going to be bedovided between you and the kids.
And that happens too.
It does happen.
Yeah.
It happens if you have a piece of property that you inherited.
Yeah.
Or bought separately.
Yes.
Now, the next natural progression of that is that's what happens if this gentleman called, if he's the first death. Mm-hmm. We have the first death and the second death of a couple, right?
Right.
Now, at the second death, we got it. Everything's in probate because now the person that got the house by survivorship, it's all in their name.
Right.
Because they're the survivor.
Right.
So that is absolute surety that's going through probate.
Yeah.
It didn't at the first death, but it will at the second. The co-ownership, last owner is now gone.
Yeah.
That's going through probate.
Yeah.
Beneficiary is, beneficiary may pass otherwise. Yeah. So I know we're getting toward the end here, and I want to go over my seminars again real
yes,
quick.
Indeed.
But I think that answered the question. And that may, more often than not, the laws of intestate succession are not what you want to have happen. They might be, but not necessarily.
Right.
But if you can control it, why wouldn't you?
Yeah,
So,
exactly. Exactly.
All right, real quickly, I know we're getting toward the end here, and the time
Got a
goes
couple minutes.
Time goes so fast
It
on
does.
this thing. But I got a couple seminars coming up. We got one. It's 2 weeks from tomorrow, which is the 18th of November. It's a Saturday, 10 o'clock right here at the WLX radio station in the back of the building.
That's right.
Sign up for that. Another one in 2 weeks on December the 2nd, which is a Saturday at 10 o'clock at the Star Theater right on the square in Pulaski, which is right next to my office.
Yes.
Again, 10 o'clock in the morning. Call my office at Pierchoski Estate Law, Pierchoski Elder Law at 931-363-7222 to RSVP. Or you can go to my website by typing in estateplanstand.com. There you can RSVP, or you can see my calendar to when the events are. You can get my email and ask a question that way, or just call my office and schedule a 15-minute phone call. I'd like the gentleman to call if you want to discuss something like that. I will call you back at a designated time, and I will have had time to think about your question. And when I call, my time will be dedicated to you and your question. So,
Estate Plan Stand, everybody.
Estate Plan Stand.
That's right. Stan Pierchoski, appreciate you being here with us again this Friday, and we'll look forward to another day.
Another episode of Bulletproof Estate
And
Planning.
don't forget those seminars. They're free and they're so easy and they're convenient right here at the studios on November the 18th, and then on Pulaski Square there at the Star Theater on December the 2nd. Those are good dates.
I call them free educational seminars, but the emphasis is on the word educational.
That's right. So, look up the website too, estateplanstand.com. So easy to do. That phone number 363-7222.
All right, Jeff. Always a pleasure to be here on Friday morning.
Man, I appreciate you. Hang in there with us.
You too.
These seconds are going to tick by, and then the Fox News break is coming up. And, of course, Stan will be back next Friday and with another show. And, of course, the phone lines will be open. Think of some questions between
This
now
is
and then.
WDXE,
Call in.
W287AA and W237FD Lawrenceburg. Broadcast services of Prospect Communications.